So, while we're on this subject, and I think it's really important for some of our listeners and viewers, if they had that guideline, if they had that set in place prior to the law change, would that be a reason for them to try and modify their current their current time sharing plan?
Unfortunately, no, it doesn't apply retroactively.
Welcome back to another episode of Law Unpacked. I'm your host, Attorney Sean, and today we're zeroing in on one of the most sensitive topics in family law: child custody. For parents navigating custody disputes, the stakes couldn't be higher. This episode will explore what courts consider when deciding custody, how parenting plans work, and how to handle modifications and disputes. Welcome back, my guest, Joshua Tyson, a seasoned family law attorney here at the DeVries Law Firm. Let's get started. Josh, welcome back.
Thanks, Sean.
What's the difference between legal custody and physical custody?
So, physical custody is the actual time sharing of who's going to have the child. Legal custody is what we also refer to as parental responsibility. That's who's going to make determinations for the child, as opposed to their schooling, for their medical, for health, religion, all the big important decisions.
Now, following up, there's also something in Florida such as shared custody and sole custody. What explain those?
Yeah, that goes right along with the parental responsibility. For shared custody or parental responsibility, the parents need to confer and jointly make all of those major decisions together. Where the child's going to go to school, whether or not a medical procedure is going to be done, the religion the child is going to practice. When it's sole, one parent makes those decisions and does not need to confer with the other parent. They can make them on their own without even discussing it.
Now, what we've learned from our previous episodes, and listeners and viewers, if you haven't listened or watched our previous episodes, this is our third in a series on family law. And so we talk a lot about the best interest of the child. What is the best interest of a child, and what role does that play in a parenting plan?
So, the best interests of the child are a series of factors that the court looks at when determining what would be in the best interest of the child, and that is how they determine their time sharing and parenting plan. Some of the factors are going to be facilitating a relationship with the other parent, the need to use a third party, such as a daycare or a babysitter, who's facilitating what tasks, any domestic violence, drug use, the physical mental health of the parents, even the moral fitness of each parent.
So, what role does the parenting plan play in custody decisions?
So, the custody decision will determine what the parenting plan looks like. The parenting plan tells the parents what the minimum they must do with the other side are. It gives us what the time sharing is going to be on a regular basis, what it is for holidays, what it's going to be over the summer. It also determines things like travel, who can travel with the child, how much notice is needed, if you're traveling out of state, whether out of country, if there are any differences, if there's transportation, whether you're meeting at a halfway point or whether one party needs to come and get the child. If you don't have the child, how often you're allowed to communicate with the child, either by phone, whether that's by text, whether it's by FaceTime. Those are all determined in the parenting plan and let you know what your rights are and what the rights of the other parent are as well.
So, what I'm hearing is everything should be outlined in a parenting plan to help custody or help making decisions moving forward with the child.
That's correct. In a perfect world, everything would be in there. Um, some things will, from time to time, come up that are not. But if you have a seasoned attorney that's putting together your parenting plan to present to the court, everything that you'll come across will likely be included.
Is it mandatory to have a parenting plan?
Yes, the court's going to enter once they enter their custody decision. It'll be outlined in a parenting plan.
Now, we talk about the court entering a custody decision. Is there any Can custody be decided outside of the court?
It can be. The parties can, of course, always come to an agreement on what they're going to do for custody. However, if you want something that's enforceable, it must be ratified by the court, and the court is always going to make sure that any decision, even if it's agreed to by the parties, is in the child's best interest.
So this one is one that hits near and dear to many households. How do custody laws handle cases of unmarried parents?
So, for unmarried parents, it's very similar to if you were married. They the same best interest of the factor, best interest of the child factor applies. The only thing was that the father would need to be first determined to be the legal father. If the parties are married, that's done automatically. If not, the father would need to file for determination of paternity. And that can be done by affidavit, it can be done by agreement. If the parties don't agree that the person filing to be the father is the father, then a paternity test will be required by the court.
What explain to me what exactly is a paternity test, or what would the court order as a paternity test?
It's DNA. Oh yeah, if it's DNA testing, they'll do generally a cheek swab of the father and of the child, and they will match the DNA to make sure that it's a match and that the father is the child's father.
Is it a good practice for all parties to always request a DNA sample, or is that where do you find that in your practice?
So usually we'll have um, no real need for them. That's usually already determined by a prior legal analysis. The Department of Revenue will do administrative cases for child support, and they will make a determination about the legal father generally prior to cases coming up for custody, which is where we would generally get involved.
So what I mean, we haven't discussed Department of Revenue. Explain to me a little bit more. What do you mean Department of Revenue would make that decision prior to a custody case?
Where neither party's filed, but if the mother of the child is unmarried and is looking for any type of state benefit, the state will automatically put the father on child support and they'll make a determination about the legal father at that time.
Why would the state do that? I haven't given them or I would say even if the mother doesn't give them the right to do so, they can go after the child, the father for child support.
Correct, because before the state is going to give any benefit to the mother, they're going to want child support put in place and then deduct the amount of child support from whatever state benefit she's receiving.
All right, so we'll get into that I think a little bit later. But now that we've covered kind of the basics of best interest of a child, let's look at process of filing for custody and what's involved. Filing for custody can be complex, especially
Sure.
if the parents disagree. Let's talk about what you need to know. What is the process for filing a custody case in Florida?
So the initial filing is very similar to a dissolution. You'll have your petition, you'll need a summons for the other side to be served. You'll need the UCCJEA so the court knows that it has jurisdiction over the child. And then you'll also need your notice of related cases, and that would include any domestic violence or administrative cases opened by the Department of Revenue. That way, the court's aware of them and can assist any decisions they're going to make based on the determinations made in those cases.
So just walk me through this, just to make sure our viewers and our listeners are hearing and understanding correctly. In a dissolution, you also need a custody case. Is that a separate matter, or does that all happen in one? And there's we've kind of talked about what I feel like are three different cases here, right? We've talked about dissolution, we've talked about custody, we've talked about paternity. Tell me, where does all this kind of lie in between, or are they all together? Help me understand this.
So, custody and divorce would be together. You would handle both of those under the same filing. Paternity and custody you would handle together. Those would both be done under the same filing. You would file to make sure you are the father, and at the same time requesting that if you are the father, ask for that custody. So that would all be under the same suit. There would never be a need for paternity and for dissolution to be established because a couple that's married automatically the married partner is considered the legal father.
Got it. So, what happens during a custody hearing?
So both sides are going to present their case as to why they feel the parenting plan they're presenting to the court is more appropriate than the other. Generally, what we're going to be presenting are a lot of the evidence that go along with the best interest of the child factors. And that's something that really having an attorney can assist with. You may not know that you want to present evidence regarding your knowledge of your child's teachers and their friends, their routine, how often each side uses a third party for babysitting and daycare.
So, what would you consider a strong evidence for a custody hearing versus what is some minimal evidence and what is really not important at all?
Uh, so something that would be very important is work schedule of the parents. If one parent works while the child's in school and the other works overnight, the court's going to highly consider that when determining the parenting plan, because the way we count the overnights in the state of Florida, the way we count days in the state of Florida, is by who has the child overnight. And if one parent would need to use a third party where the other wouldn't, then the party that wouldn't need to use that a third party for watching the child would be in a extremely strong position as opposed to the one that does work overnight. Something that might be a little less relevant, you know, arguments between the parents not being able to effectively co-parent. The court's already made determinations that that is, uh, not something they're going to take into account when determining what would be a substantial change.
Let's move on to domestic violence. How does domestic violence impact custody?
So certainly, if there is a domestic violence case already in place, one parent may be barred from being around the children, and so in the event that that's occurred, that parent will likely have time that would be supervised.
And what do you mean by a time that is supervised?
So there's two ways to do supervised time sharing. It can either be done by a parent or third party, someone that is selected by the parent, or what we commonly do is have the local family nurturing center handle the supervision. They will make sure that they're listening to all the conversations. They make a document of every visit you have with the child. They're in a secure location. You can make sure that they're not able to flee with the child if that's a concern.
Okay. So, what role does a child psychologist play in custody disputes?
So a child psychologist would determine, the mental and physical needs of the child, which can come into consideration in the best interest factors, or if there is a question about the child's mental competency, to give their preference, because it is a reasonable preference of the child that's considered for best interest. And so they may make a determination on whether or not the court should consider the child's testimony.
So, going back, how do you get a psychologist involved in a custody dispute?
So if you wanted one appointed by the court, you would need to file a motion for that. You can do a motion for a psychologist evaluation. You can do one for a social investigator, for a guardian ad litem, all of which will do an interview with the child and give each has their own pros and cons, essentially. The psychologist has their medical background to fall on, um, whereas the social investigator can interview the child, present their report, and is not subject to the rules of hearsay.
Are these appointed for free, or would the court automatically appoint them?
No, they are not appointed for free. There is a cost. Whatever psychologist or social investigator is being used, you will need to pay whatever their rates are. Now, when they are ordered, the court also orders who is paying the fee for that.
What are those fees range, or what have you seen those fees range, just to give our listeners and viewers kind of an idea of what to expect?
Sure. On the low end, you're looking at between $2,000 to $2,500, and about $7,000 to $7,500 on the high end.
So, can children decide which parent they want to live with?
No, the child can't decide. They can give their preference, and the court will take that into consideration. but it is not given more weight than other factors in the best interest of the child factors.
You talk about the best interest of the child factors. Do you know, can you tell us what those factors are?
Sure, yeah, we've got the ability to foster a relationship with the other parent, the need to use third parties, any evidence of domestic violence or that someone has given false claims of domestic violence, the moral fitness of the parents, the physical and mental health of the parents, the length of the child being in a stable and satisfactory environment, the school and community records of the child, any the ability to keep the child in a drug-free environment, and then there's a catch-all at the end for any other relevant factors the court might consider.
So we know that, let me go back real quick. So, when you are going through a custody case, are you trying to prove each one of those factors, one or the other factors? How does the court view those factors?
So generally, equal weight is given to each of the factors, and so we will go through and try to prove each factor that we can, and weaken any claims that the other side would have on each factor.
Now we know statistics tell us that a person doesn't typically stay in the same house for more than 5 years. So people move. We expect that. How does relocation affect custody cases?
So if you're moving more than 50 miles as the crow flies, is what the statute says, um, then you would need either the consent of the other parent or the approval from the court to move and still maintain that time with the child.
As the crow flies, I can't believe that's actually in our Florida statutes. That might be one that we quote from here on.
I don't think that's actually in the statute. That is in case law. I want to clarify that.
Perfect. Now let's explore what happens when disputes arise and how courts resolve them. Disputes in custody cases can be challenging. Let's discuss how these are handled and what happens if parents cannot agree on custody. How does the court handle allegations of abuse or neglect?
Generally, what the court will do is they'll have a hearing on it and they'll make a determination if they need someone to investigate. They may appoint a social investigator to talk to each parent, to talk to the children about any abuse or neglect claims.
We've often heard the term parental alienation. What is it and how is it addressed in court?
So, parental alienation is when one parent tries to keep the child from the other parent and damage that relationship. That can be done by them telling the child that the other parent doesn't want to see them. There's a multitude of ways it can express itself, but the crux of it is that you are keeping the other parent from the child. The court very negatively looks upon it. That is why when they put their parenting plans in place, they generally call for substantial time with each parent unless there has been neglect or abuse proven to the court.
Now, we talked earlier about custody orders with that includes supervised visitation. Will somebody that gets supervised visitation always have to have supervised visitation?
No, that can change. Ultimately, we'd like it to change. Being reunified with the child in an unsupervised setting is always the goal of the court, and it should be the goal of the parents. However, you will need to prove that you've made the changes in your life so that the court is aware that the child will be safe in your care.
Tell me, what are the. So let's moving on. So the court puts this custody arrangement in place. What happens if one parent or another violates the custody order?
So, if one parent violates, the other parent would file a motion asking the court to hold that other party in contempt. The court will listen to the evidence as far as what happened and order the parties to follow the court's order, generally on a first violation. The court's just going to tell you that, hey, you cannot do this. You are in violation. If you continue to act in this way, the penalties for you can get increasingly severe, up to incarceration.
Wow. So you can be arrested for violating a custody order, is what I'm hearing.
That's correct. Now, it's very rare that we get to that point. Generally, after possible modifications to the time and fines from the court, it gets the point across. But yes, incarceration is an available option to the court.
So, in previous episodes, we've discussed alternative dispute resolution, specifically mediation. Is that available to parents that are going through custody uh, issues or custody cases?
It absolutely is. In fact, it's something that the court is going to order before you have a trial, so that you can try to work it out amongst yourselves what the time sharing should be.
What are some of those examples of what time sharing should be?
So, right now in Florida, we have a presumption of 50-50, and there are a multitude of ways that we can do that. Generally, what we do is a week on, week off schedule. Some parents don't like that. They feel the full week is too long, and you can make a determination to do what we call the 2-2-3, which is where one party would have Monday and Tuesday, the other would have Wednesday and Thursday, and that's set every week. And then they would rotate every other weekend. If you don't have equal time, one of the more popular options that we have is the non majority parent having every other weekend from Friday to Monday, and then every week having one night. We generally try to make that a Thursday so that when it is your weekend, you can just do that Thursday to Monday.
So, I think what I've heard and what I've heard in the past, so I think maybe the law has changed a little bit in the last couple of years with this presumptive of 50-50. Is there no longer the every other week and one weekend, one weeknight a week? Is that not uh, a guideline at this point?
That's correct. That was the local guidelines for Duval County. It was every other weekend, one night during the week for local time sharing. But with the presumption of 50-50 that went into place in Florida last year, it is now a 50-50 time sharing that the court should be looking to put in place.
So, just to, while we're on this subject, and I think it's really important for some of our listeners and viewers, if they had that guideline, if they had that set in place prior to the law change, would that be a reason for them to try and modify their current their current time sharing plan?
Unfortunately, no, it doesn't apply retroactively.
So how can and that's definitely unfortunate because I can see where lots of parents would want to go back in and try and what are some of the factors that would allow them to is there any factor that would allow them to come up to the new 50-50 presumption?
Sure. To modify, you'll need to show the court a substantial change in circumstances. And that can be, it mainly is a person who previously lived out of state, now living locally, or if you've had a change in your job to where you are working hours that will allow you to effectuate time more efficiently with the child.
Great. So let's continue on this path of discussing how custody orders can be modified and enforced after they've been issued. So, custody arrangements may need adjustments over time. People move, things happen, work changes. Tell us again, when can custody orders be modified in Florida?
So, for modification in Florida, you're going to need to show the court that a substantial change in circumstances has occurred. Moving can be one to where the other party can no longer effectuate the time sharing plan. Change in your work hours, change in your living situation. Say you lose your job and now you had to move in with a family member, and there's no longer adequate space in the new home for the child or children. They may not have their own bedroom at your new place. The other parent may want to modify the time sharing that is currently already been entered by the court so that the court knows what's going on and can make an appropriate determination for what's in the child's best interest moving forward.
If the court modifies or a parent moves to the court and they agree to modify time sharing, Would that also adjust child support?
It would. As long as if there is a change in the overnights, you'll need to recalculate child support, which means you will also need to go back through the financial disclosures that we discussed in previous episodes. And the court is again going to look at your most current income and the amount of overnights they're now putting in place and would modify that child support along with the custody.
So we always want parents to work together. Is that an accurate statement?
Yeah, when parents can work together, it's so much easier both on them on and generally also mainly on the child when there's not that animosity back and forth.
So let's assume parents are working together as we always want them to because that's going to be in the child's best interest. And one child starts spending more nights with one of the parents that's not in the agreement, would that be a reason to be able to go back and modify someone's child support arrangement?
It can be if it's a significant amount and is happening on a regular basis. If the child's just spending an extra night or two on occasion with one parent, you likely wouldn't qualify for what we consider a substantial change. But if the child is routinely staying 5 nights with one parent per week as opposed and two with the other, and you have a 50-50 agreement, the parent who has the 5 overnights would certainly want to modify just so that they can, one, have that time put in place for the stability of the child, and having the child that extra amount, you're going to incur a lot of additional expenses. So you would want that child support modified as well.
And when somebody, let's say, takes a job out of state, how does that relocation affect existing custody agreements? Do you automatically have to go back to the court? Do they automatically know? What's the easiest and worst case scenario with that?
So, easiest case scenario is the two of you are in agreement. You enter into a modification, have it ratified by the court. It's a fairly simple process when the two of you agree. If you don't, the party that's looking to move would need to file with the court. You would likely need to attach your job offer and let the court know how you taking this job out of state is going to better the lives of the children.
Well, with regards to child custody, is there anything that I didn't ask that you believe our clients or viewers or anybody listening should know?
Nothing comes to mind. Just always, be reasonable when you can, and try to understand that the courts are going to let you know that the child is the child of both of yours. You can't treat the child like it is your child, and the other person is just facilitating watching the child while you're not around.
Well, Josh, thank you so much for joining us today. We really appreciate your insights, especially when it comes to paternity actions and child custody arrangements. This is Law Unpacked. I'm attorney Sean. We'll see you back here next time. Take care.